Hello, everyone, and welcome to today's webinar, Most Efficient Way to Title Real Estate Assets for Future Wealth Transfer and 1031 Exchange, presented by Joe Michaelitz and Mike O'Toole. My name is Amanda Jenkins, and I will be your host. I work as the Education Manager here at the Realtors Land Institute, and I'm really excited to be a part of today's session. The Realtors Land Institute, or the Voice of Land, continually strives to maintain its status as the acknowledged leader for all matters pertaining to the land real estate professional. RLI endeavors to remain the essential membership organization for the real estate professionals who broker, lease, sell, develop, and manage our most precious resources, the land. And we're here to provide our members the expertise, networking, and valuable resources that are the foundation for all land real estate professionals to become the best in the business. We'd love to hear from you during today's session. Feel free to type your questions in the chat box, and our facilitators will answer them at the end of today's session. Please make sure your computer and your phone are on mute, so that way we can eliminate any background noise and any echoes. I'm pleased to introduce today's facilitators, Joe Michaelitz and Mike O'Toole. Joe has 32 years of expertise in the financial industry. He founded Discipline Advisors, an SEC-registered investment advisory firm, in March of 2006 to manage his clients' investments, using his unique process to maximize risk-adjusted returns. Because Joe is a strong believer in complete diversification, he has expanded the firm's service offerings to include private equity and private real estate alternatives. Along with advising clients and implementing investment strategies, Joe is involved with the investment committee and actively participates in the due diligence process. He's passionate about advocating for his clients' financial well-being, and he continuously seeking opportunities to add value to his clients of DAI. Mike O'Toole has 14 years of real estate and investment securities experience, and 10 of those have been in securitized real estate and DST sponsor. He has over 3 years' experience as a real estate agent broker and advises clients with investment planning with a focus in real estate, 1031 exchanges, and other financial planning and estate needs. Mike has a strong knowledge base and experience with the process of underwriting, developing, and syndicating commercial real estate offerings. Mike and Joe, we want to thank you for presenting the webinar today and all that you do to support RLI. The floor is yours.
Well, thanks, Amanda. Really, we just hope to accomplish some education here on behalf of all of those of you who are joining us. I think what I want to do is just give you a quick overview of what I hope to accomplish here, and we can answer questions, of course, at the end. But I've worked with a lot of RLI members over the years, helping them find quality exchange programs for their clients. Oftentimes, a lot of RLI members will have, clients sitting on the fence. They don't know if they want to list or not, because if they sell the property, of course, are there taxes that need to be paid? How can we get around the taxes? Well, that's easy with the 1031 option. A lot of people think they have to just exchange back the land. There's a lot of other things that qualify as replacement property. And we just try to help people just to see what it's going to look like if they sell the farm. What is it going to look like afterwards from a diversification perspective? What's their income going to be? What's their tax situation going to be, and so on and so forth. So some of the obstacles that we run into that I really think it would be good for you all to understand is really the proper way to title assets. So we're going to spend quite a bit of time about that. And of course, it's always important to know what really your client's goals and objectives are. And when we talk about goals and objectives, oftentimes we're going to be just, trying to find out really what they want to accomplish with the, we're trying to advance our slides here, and for whatever reason they're not advancing. Let's see if we can get it to work. Well, I'm going to keep talking, and I'm going to cover everything, but we'll see if we can get the slides to advance here real soon while I'm talking.
So if you want to unshare or pause sharing your screen while you work on that, you could do that.
Okay. All right, so it's, but anyway, I'll just keep talking, and then I think we'll get the slides to get in sync with us shortly. But when we talk about goals, a couple goals that always come to mind when we're talking with people looking at selling their farms and ranches and different things is, do they want to keep this? They want to transfer this wealth down to the next generation, to their kids. Are they still actively engaged in the farming operations, and they're just looking to acquire more land and improve that property and continue to add to the bottom line of their farming operations? A lot of farmers, ranchers are, as the old saying, asset rich, cash flow poor. Sometimes they want to diversify and eventually maybe sell some of their assets and diversify into some other types of real estate that generates more cash flow to them, has more tax efficiency, and maybe is easier to transfer down to the next generation. And we'll talk about some of those things farther as we go. But let's first talk about types of ownership. It really makes a difference how your clients own their real estate. And I'm going to give you some examples real quick. So we'll talk about individual ownership, joint tenants. Tenants in common is a form of joint tenants, but we'll talk about the differences. If it's owned by a corporation, can be a C corp, S corp, LLC, etc., or a trust. So as far as individual ownership, it's simple, inexpensive. We say lender friendly because the banks, it's really easy for banks to underwrite a loan. If you're borrowing money and you just own the property individually, pretty simple from an underwriting perspective. As far as cons, lacks liability protection, and you have estate issues with probate. And probate, for all of you that, most of you probably understand it. For some of you that don't, I'll just summarize it real quick. So probate is the process of the distribution of your wealth after you pass away. If you don't have a trust, or you don't have, beneficiary designations to individuals on trusts or IRAs and different things like that, everything else will go through probate. So your will is really the roadmap to the probate court, how you want your assets distributed. I will tell you, just quite honestly, that probate is 100% unnecessary. It's a waste of time and money. And so whenever we're looking at how clients have their assets titled, we want to make sure that we follow through the whole process and make sure that at the end, when these assets transfer to the next generation or transfer to a surviving spouse, that it's as efficient as possible. And avoiding probate is one of those items that we want to avoid if possible. And usually we can always avoid it. So individual ownership is fine. Joint tenancy by itself will avoid probate at the first death. So if husband and wife own an asset, it's owned joint with rights of survivorship. When the first person passes, the survivor will automatically assume 100% ownership in that asset. One of the negatives is because it was owned jointly, the surviving spouse will only get a stepped up basis on half of the asset. And the other basis, of course, is the original basis on the other half, which the surviving spouse would have. If you own assets, tenants in common, that means that the two people have an undivided 1/2 interest of every acre of the parcel. So the first joint tenant, when they pass away, it doesn't automatically go to the surviving joint tenant. It will go through their will or go through their trust. And so there are pros and cons of that as well. And we can talk more about that a little bit later. But I want to move on and talk about some of the other types of ownership. Next would be the limited liability company, LLCs. They provide liability protection. Oftentimes it's more efficient in transferring because of the title structure, which I'll talk about, and gifting and so on and so forth. A little more flexibility. Some of the negatives, it does cost their setup fee. Some states have an annual filing requirement. You're still going to deal with the state issues and probate and potential lender constraints. But when it comes to owning assets for doing another or being able to do a 1031 exchange, I'm going to summarize something real quick and keep this, all of you keep this in mind. If you ever have a client that asks you what's the best way to own this real estate, there are a lot of reasons, but the most important reason is ask them if they ever plan to do if they plan to do a 1031 exchange someday when that asset is sold. Because if they do plan to do a 1031 exchange down the road, when and if that asset is sold, then they're going to be better off owning that asset. If it's individually, then it should be in an individual trust, revocable trust. That will allow them to do a 1031 exchange, but also ultimately when they pass on, that asset will avoid probate and go to the intended heirs without having to go through probate. If it's in an entity like a partnership, that's fine. If it's an LLC taxed as a partnership, that is fine. When I say that is fine, what I'm meaning is that those assets, when you have multiple owners, those assets can be distributed out to the individual owners based on their ownership interest. And just the transfer of those assets to the individual owners before they're sold does not qualify or does not create or cause a taxable event. And where that asset was titled in an LLC taxed as a C corporation, or if it was held in an S corp or a standard C corp, you cannot remove those assets and distribute those assets out to the individual owners of that corporation without creating a taxable event. And a lot of people get caught in that trap. And so the example would be this. I've had many situations where you have, let's just say, 2 or 3 brothers that are farming together, and they own the farm in a corporation. And one of them wants to retire, and any number of things can happen. Obviously, he can be bought out by the other 2. But let's just say they all decide they want to sell the farm and they all want to go their separate ways. Well, if they were to sell the farm and go their separate ways, meaning that each one would dictate what they want to do with 1/3 of their proceeds, that can't happen without creating a taxable event. So what they would have to do to defer all the taxes on the gain would be to keep the asset in the C corporation. And they can do 1031 exchanges within the C corporation, but they can't do a 1031 exchange outside of the C corporation without creating a taxable event. And that applies to LLCs taxed to C corps. It applies to S corporations and, of course, standard C corporations. Now let's take that same example and say that these 3 brothers own this farm operation, own the real estate in a partnership. Well, in that situation, they could dissolve the partnership and distribute the lands to the 3 of them, and they would own it as tenants in common based on their ownership interests of the partnership. So if they were a third owners, then they each would own 33 1/3% of all the real estate. And when that real estate is sold, they each can do a tax-deferred exchange into whatever they want to exchange into, and it does not create a taxable event to do that. Again, if it was a C Corp or an S Corp or an LLC taxed as a C Corp, then that would be a taxable event, and they could not do individual 1031 exchanges. So LLCs can be taxed as a partnership. Matter of fact, every time an LLC is set up, you have to elect what the tax status is. And I would always encourage everybody that owns real estate to make sure that you elect to treat the LLC and tax it as a partnership, never as a C Corp, because that'll create problems like we've been talking about. There are limited partnerships themselves that can be used, and limited partnerships work pretty much the same as a partnership, but there are some advantages to a limited partnership that you don't have in a regular straight out partnership, and one of them is asset protection. In a limited partnership, you have general partnership interest and you have limited partnership interest. We don't have them on our slide here, but just real quickly so you understand, limited partnership interests have no control over the assets. So many times, we will have clients that mom and dad will set up a family limited partnership. They will retain the control, and the way they retain the control is they own the general partnership units. And they can gift the limited partnership units to their children. And so it's a way for them to transfer wealth to their kids but not give up control. And it also provides asset protection because if one of their kids was sued or went through a divorce, even though they have this asset in their name, which are, is maybe it's 50% interest in a farm, but their 50% interest is in limited partnership interest, they really have no control over that farm. So a creditor cannot attach to those assets because the child cannot sell those assets. Only mom and dad, whoever owns the general partnership interest, can sell those assets. So the creditors might put a charging order against those assets, those limited partnership units. And all that just means is that eventually down the road, if there's ever a liquidity event and mom and dad do sell the asset and the kids get cash for their share, then creditors could attach to it. But we oftentimes will make sure that the general partnership interests, after mom and dad pass on, go into a trust and have a trustee who then continues to control those assets and protect them from creditors. I don't want to get too deep into the weeds on some of these things, but we spend a lot of time, with our clients, making sure that they understand the pros and cons of all these different ownership structures to make sure that they're owning the real estate the most efficient way to accomplish their goals. We also have trusts. Well, I talked about corporations, but I think I hit that enough as far as, S Corps and C Corps. You just really never want to own real estate in an S Corp or C Corp if you can help it. And then trusts are a great tool. There's two types of trusts. A lot of you are familiar with these, but you have revocable trusts, which are commonly referred to as living trusts. And these are trusts that, you've created while you're living, and they're also revocable, meaning that you can change them anytime you want or revoke them anytime you want. From a land titling perspective, it's very simple. The tax ID number of a revocable trust is your own individual Social Security number. So from a tax planning perspective and everything else, there's no change. But revocable trusts do have beneficiary designations, so they fall under what's called the law of contract. And when you have beneficiaries override a will. So if you had land you owned in a revocable trust, and the beneficiary of that trust was your wife or your spouse, but you also had a will, and your will said that the land was listed and that you wanted the land and your will to go to your 3 children, it doesn't matter what your will says, it's going to your wife because your wife is the beneficiary of the revocable trust, and that has more precedence over a will. And of course, the transfer to the spouse is a non-probate transfer, where anything that goes through the will must go through probate. Other aspects of the revocable trust that are really important is if you own real estate in more than one state and you don't own it in a trust, then each state requires upon death that any real estate that's domiciled in their state must go through their state-specific probate process. So I've literally been involved with clients who their surviving spouse was referred to me, and a lot of the real estate was in Dad's name. Dad owned farms in 4 different states, and unfortunately, he did not own it jointly with his spouse. He owned it as tenants in common with his spouse, which means that his estate controls 1/2 of the asset, and of course his spouse already owns 1/2 of the asset. But to transfer his half to her through his will, there had to be 4 state probate processes to go through, and by the time that was all said and done, the costs were over $50,000 just to retitle his undivided half into her name because of how poorly the estate was set up. So had those same undivided 1/2 interest been owned in a revocable trust with his spouse as the beneficiary, that would have all transferred in one day. Total cost would have been about $100 per deed, $400, and that's it. It's all done. Would have saved $50,000 and a lot of time and a lot of headaches. So, we deal with a lot of clients. We have clients. Our firm has clients in 30 states, and most of our clients own real estate in a 6 states or more, because we utilize a lot of Delaware statutory trusts as exchange replacement programs, and a lot of the Delaware statutory trusts own real estate, in multiple states. And so we try to make sure that all of our clients, from a wealth transfer perspective, own all of their real estate inside of revocable trusts. And it just, again, very efficient, no probate hassles, and it just makes everything a lot smoother. Let's see, what else we got here? I guess we've been talking about the right way to title property. That was a big part of our presentation. State considerations for landowners. We talked quite a bit about wills and probate and revocable trusts already. I will just kind of summarize again just the differences. So some people just don't have a will or don't have anything. And they'll say, well, it's all going to go to my spouse, and I believe that's what's going to happen if I die and I don't have a will. It's all going to go to my spouse. So I'll just educate you real quick on just the basics around wills and why you should at least at the very least have a will. Every state has their own laws of intestacy, and what intestacy means is it just means that you died without a will, or you died intestate. So it's a legal term, but what it means is when you pass away without a will, then your state will have a will for you, and it's in their laws of intestacy. And the default is for everything to go to the surviving spouse, and that's where it all goes first. And if there is no surviving spouse, then it goes to children in equal shares. So it pretty much will do what most people will default to do. But the difference is that if you don't have a will, then to go through the intestate procedure, it requires what's called formal probate or supervised probate. And that's the old traditional probate process that's been around since the 1800s. It's very, very expensive. It involves an attorney. It involves court appearances and hearings. And I've seen situations where people didn't have a will, And just to transfer their house to their 3 kids, because it was a surviving spouse that passed away, and they didn't have a will, and the house was not titled jointly with the 3 kids, which would have avoided probate through joint tenancy. But anyway, to go through the laws of intestacy in that state, it cost $35,000 just to transfer the house to the 3 children because of the legal system, and it took 9 months to get it done too. Where if mom in this case would have had a will and says, I want the house to go to my 3 kids, it would have went to the 3 kids. It still would have went through probate, but it would have went through an informal, unsupervised probate process, which would have taken about 4 months instead of 9 months, and would have cost about $2,500 instead of $35,000. So a will is still better than nothing, but it's still not nearly as good as a revocable trust. Retirement accounts and life insurance policies, just for you all to know for yourself, you always have beneficiaries designations. And again, beneficiary designations have more precedence over a will. So whoever you have as the beneficiaries on your retirement accounts and on your life insurance policies, that's where the money is going. That money will never go through probate. Let's see, 1031 exchange estate considerations. We've talked about titling quite a bit. Let's talk about debt replacement a little bit. I assume a lot of you on this call or on this webinar are familiar with 1031 exchanges. You've probably, done a lot of 1031 exchanges. But where I see questions that come up often is in the handling of debt. So if an asset is sold, if a farm is sold, let's say it's $1 million farm transaction and it had $300,000 of debt on it. Well, that debt is going to be paid off at the closing when that farm is sold. If the intent is to do a 1031 exchange and your client does not want to pay any tax at all, they want to defer all the tax, then you just need to arrange for, in the assets that they're going to exchange into, you need to arrange for at least $300,000 or more of debt in the assets that they're exchanging into. And as long as you replace all of the debt or more in the exchange assets that was, paid off at the closing, then the entire exchange will be tax deferred, and there will not be any boot. And boot is the difference between, the example would be, again, if we take that $1 million farm and it's sold, there's $300,000 of debt. The debt gets paid off at the closing. There is $700,000 of equity left. If you just took the $700,000 of equity and bought another farm, even if you, we'll just keep it simple. You bought another farm and you paid $700,000 for it. The fact that you didn't, first of all, replace the $1 million asset with another $1 million asset, that would trigger recognition of gains, capital gains. So 30% of whatever the capital gains were going to be will be attributable to you and taxable. Also, because you didn't replace all of the debt, then the difference that you didn't replace is called boot, and that's also taxable, as a capital gain. And so there's always 2 tests that need to be met. The first test is to defer all your gains. You need to make sure that the acquisition value of the assets you're exchanging into are equal to or greater than the assets you sold, and that the debt that was paid off at the closing, if there was debt, the same amount of debt or more needs to be replaced in the exchange assets. If both of those tests are met, then the entire exchange will be tax deferred. Sometimes we'll use strategies. We utilize a lot of DSTs. I referenced that earlier. DSTs can be structured to have debt inside them. One of the advantages that a DST has with debt is that debt must be non-recourse to the investors. So we can replace debt for, our clients that are selling land and have debt that needs to be replaced. We can replace recourse debt with non-recourse debt. And again, any debt that they would have on that farm, obviously they're liable for it. But when you exchange into a DST that has non-recourse debt, they get the benefits of that debt. It still helps meet the tests, the tax deferral tests, but it's debt that they are not liable for and will never have to pay back personally. So there are some strategies that can be used to help people in their 1031 exchanges to make sure they're tax deferred and to handle the debt scenario. Also, a lot of people sometimes think that when you do a 1031 exchange, that you have to exchange 100% of the asset. You do not. You can do partial exchanges. We do partial exchanges all the time. And an example would be sometimes people's income, they're not in a real high tax bracket. And so whenever you have a capital gain, the way it's looked at for income tax purposes is it is first added to your ordinary income. And if it would have been taxed in now the 12% tax bracket or lower, the capital gains rate, the federal capital gains rate is 0. So under the new tax law, if you were to look at a couple married filing a joint return, they would have a $24,000 standard deduction, and the tax bracket doesn't go from it goes from 12% to the next bracket, which is 22%. That's at about $77,000. So if you take $77,000 and add a standard deduction of $24,000 on top of it, you can see that couples filing a joint return, they don't go into the next tax bracket until basically $100,000 of income. That means that any capital gains that they would receive in a taxable year, when added to their ordinary income, would not put them over $100,000. The capital gains rate is 0. A lot of people don't know that. And so whenever we're working with people and doing 1031 exchanges, I'm always trying to look at their tax returns to see what their income is, and if they can hold back any part of their exchange proceeds and be able to hold that back and have 0 tax on it, that's always a wise move to do. So we do a lot of partial exchanges. Sometimes people maybe want to hold back a couple $100,000 for different things and exchange the balance. No problem, they can certainly do that. Just trying to think of some other things here before we start taking questions. I think I've handled a lot. There was a kind of a family example, our last slide, a little case study, but I kind of went through that already. So I'm sitting here, talking to you all, but I can't see you, and you can't ask questions as we go along. So I think, Amanda, I think I covered the material that I really wanted to cover. So why don't we see if anybody has any questions at this point?
Absolutely. Thank you so much, Joe and Mike. Guys, if you guys have questions, up on the top of the screen, there's 3 buttons, and there's one that looks like a little, I guess, kind of a speaker box that you can click and type in questions. So if you have any questions about the webinar or anything for Joe and Mike, you can go ahead and type those in there now. And we'll read them out loud for everyone to hear and give them a chance to answer. Do we have an, okay, we have one. What is the best way to title a property? Terry Jensen asked, and said, sorry, she was interrupted with a call and did not hear that part.
Oh, the best way to title the property?
Yes.
Oh, well, I know we went through this in quite a bit of detail early on, but if it's a real estate asset and the client intends to or wants to have the opportunity to do a 1031 exchange in the future, that property, should be titled either, individually. It could be titled joint with another individual. It could be titled in a partnership with other individuals, or it could be titled in an LLC taxed as a partnership, with other individuals. So the key is you don't want to have that property held in an S corporation or a C corporation or an LLC taxed as a C corporation. That will create restrictions on the ability to do 1031 exchanges in the future. You can still do them, but you have to do them within the entity forever. You can never move that asset out of the entity without creating a taxable event. Where with the other structures, individual ownership, joint tenancy, LLCs taxed as a partnership, partnership agreements themselves, they can be, those assets can be moved outside of those entities, and then the individual owners, based on their ownership interests, can exchange their proceeds into their own exchange programs independent of each other. In other words, those assets can be moved out of the entity in the future without creating a taxable event. I hope that answers the question.
Yes, thank you. Someone asked if you could explain further the 0% federal capital gains tax.
Sure. So the capital gains tax, I'm just trying to get the easiest way to explain it, but the capital gains tax rate is 0% for any capital gains that would ordinarily be taxed at the 12% tax bracket or lower. So any income, any capital gains that a person would have in a year, and again, I'm talking about long-term capital gains, not short-term. Long-term capital gains, so those are assets that have been held, 12 months or longer. If there's a gain on that asset, the gain itself then gets added to the individual's ordinary income tax scenario. And whatever tax bracket it would have been taxed at from an ordinary income perspective, that's the bracket that's going to determine what the capital gains rate is. So if the income would have been taxed at the 12% bracket, so I'm going to give you an example. So I talked earlier about the couple married filing joint. Let's say that their joint income is $80,000, and they sell a long-term capital gain asset. And let's say that long-term capital gain asset, they recognized a gain of $40,000. Well, if you add the $40,000 to their income, the first $20,000 is going to get them up to the maximum, up to the threshold of the maximum of the 12% bracket. So again, at about $100,000 of income, because of the new tax law and each person having a $12,000 standard deduction, so married filing joint, they have $24,000. So if they had $80,000 of income, ordinary income, and the first $20,000 long-term capital gain of their 40, when added to their ordinary income, would have been taxed at the 12% bracket. So that means that the first $20,000 of capital gain, the capital gains tax rate would be 0. And then the other $20,000 of capital gain would have been taxed at the 22% bracket. And the capital gains rate for that, so any income, any capital gain that would have been taxed at the 22% bracket up to the 37% bracket, I take it back, up to the 35% bracket, would be taxed at 15% federal. And then you have any capital gains then that exceed $250,000 in a year. You have an additional, the Affordable Care Act, or the old, what we call the Obamacare tax of 3.8%. So that applies as an additional tax on any unearned income that exceeds $250,000 in a year. Then that 3.8% would get thrown on top of the 15. And then any capital gains that would have been taxed at the 37% bracket, which is $600,000 now. Actually, I take it back. The capital gains rate, they still have a lower threshold for capital gains, and I believe it's at, I think it's 480. So any capital gains that exceed $480,000 in 1 year, then the federal rate's 20% plus the 3.8%. So it'd be 23.8%. And that's assuming you live, in Texas or Florida or South Dakota or Nevada, states that have no state income tax. If you live in Minnesota, you can throw another 9.85% state income tax on top of that. And that gets pretty spendy. So I hope that answered the question in regards to how capital gains are actually taxed. And again, a lot of people don't understand that, but it's nice. It's good to know that. So people, when they do an exchange, if their joint income is less than $100,000 in a year, then hold back some capital gains, hold back some assets that have capital gains to max them out at the $100,000, because, and the example would be this. Let's say that they sold an asset and the capital gains were 50% of the sale proceeds. So let's say they sold an asset for $200,000 and their cost basis was $100,000. Well, that means their capital gains are $100,000. But if to recognize $20,000 of capital gains tax, they'd have to hold back $40,000 of that asset, because 20,000 of it, or 50% of it, is their own cost basis coming back, which is not subject to tax. And the $20,000 gain then would be subject to tax, only if it was would have created them or been added when added to their income, that would have been taxed at a bracket higher than 12%. Otherwise, that would be tax-free as well.
Thank you. Great question.
Any other questions, Amanda, that anybody has?
Yes, we have one more. If you have an elderly or ill parent, is there a time limit between the time they change the ownership to a revocable trust and their death that has to be met? Or could it be, in theory, the very same day?
Yes, there is no time requirement. If they set up a revocable trust and transferred their assets into it the same day, in other words, if they executed their trust, which means they signed it, and they also retitled their assets into it that day, then if they passed away that evening, there's no probate. Everything transfers to the heirs with no probate. And of course, they have to be of sound mind and things like that. You can't set up a trust if you're mentally incompetent. The other thing to remember too is that the beauty of these 1031 exchanges is some people say, well, someday you got to pay the tax. It's not like an IRA or a retirement plan where someday somebody does have to pay the tax. Real estate, just like a lot of other assets, the heirs will get a stepped up basis upon death. Death being the triggering event. So, there's funny analogies that we use in our industry, but one of them is you keep flopping your assets till you drop. In other words, just keep flipping them, keep exchanging, and keep deferring the tax until death, because at death, then the cost basis gets stepped up to fair market value at death, and that's the new cost basis to the heirs. And of course, when they sell the asset for that same value, there's no tax. If they hold on to it for a while and they sell it at a value that's higher, then they'll just realize capital gains only on that difference between the value it was at when they inherited it compared to when they sold it. So the 1031 exchange really makes a huge difference for people. The other thing I'll try to explain over the phone, and if you want to draw this on a piece of paper somehow, it's the old rule of 72. And if you haven't heard of the rule of 72, you just simply divide into 72 what your anticipated growth rate is on your assets, and the result is how many years it takes to double your money. So the example would be, for us and our clients, we use 10% as our average growth rate because we've had, since 2004, we've had, I think, 57 liquidity events now with DSTs, and the average growth rate to our clients has been 10% or more. But if you took 10 and divided it into 72, it goes into it 7.2 times. That means that your wealth doubles every 7.2 years. So if you take somebody who's, 60 years old, and let's say they do a 1031 exchange, they sell an asset and do a 1031 exchange. Let's just say it was a very low cost basis asset, and they sold it for whatever, $1 million, $1.5 million. And let's just say that their capital gains tax, if they didn't do an exchange, was $200,000. Well, that's $200,000 of wealth that they get to keep, and they get to invest, and they get to earn income off it, and they get to grow it. And so by the time they're 67 years old, that $200,000 of tax savings is now $400,000 of tax savings. And if we add another 7 years to it, so now they're 74 years old, that doubles again to $800,000. And if we take them out to, say, age 81, that's $1.6 million. So you take somebody 60 years old that does a 1031 exchange and they defer $200,000 of tax. By the time they're 81 years old, they've created $1.6 million of additional wealth for their family, because when they pass away, that full $1.6 million is going to transfer to them with no tax. So you have to really think hard about what other asset could you exchange into and after tax, and generate that kind of growth and that kind of wealth and that kind of tax efficiency, just to replace the tax savings that you would have had by doing a 1031 exchange. I'll just kind of, just at the tail end of this, I'll just add, we've worked with a lot of RLI members over the years. Maybe some of you are probably on this call, on this webinar, but we help a lot of people, a lot of our RLI people get listings, because if you ever have a client that's sitting on the fence and just doesn't want to sell because they're either afraid to pay the tax, they just don't know what they'd exchange into. What we try to do is just help create that picture that what would it look like if they did sell, after the sale, if they did a 1031 exchange, what would it look like? Meaning, what would they own? What would their income be? What would their net after-tax income be? With raw land, it's not depreciable. So a lot of people that own land and they're not farming it anymore, they're just cash renting or sharecropping. There's no depreciation to offset that income. Where with other types of real estate, multifamily apartment buildings, medical office buildings, assisted living facilities, self-storage facilities, all of these assets are depreciable. And multifamily assets are depreciated over 27 and a half years. And when you do the math, most people that do a 1031 exchange into a Delaware statutory trust or a DST, as we talked about, and they might own an interest in a 300-unit Class A apartment building in Nashville, Tennessee, as an example, that thing will be kicking out about 6% income to them. And oftentimes, 100% of that income is tax sheltered, meaning that none of it's taxable. So when you take the after-tax returns of some of these other qualified replacement programs and compare them to the net farm rent, if they're just renting it out, or if it's, you know, CRP ground or whatever it is, oftentimes we can help people double or triple their income, defer all their tax, and still create, you know, an excellent wealth transfer vehicle that will get a stepped-up basis to their heirs. So if ever we can help answer questions, and you know, our contact information, I think, is on the slides here, and we do have a toll-free number. Feel free to call us anytime. We're happy to help. Usually we try to always have a presence at your annual conference. Unfortunately, the last 2 years we haven't been able to make it. 2 years ago because of a death in the family, and this year because of an ice storm we couldn't get out of the airport. But we hope to be there next year and continue to sponsor RLI. We just appreciate the professionalism of all you members, because you really are a good, you know, top class of realtors that we compare all the time. There's a lot of realtors out there, as you all know, that just are not what I would classify as professionals. But you guys are great. So, Amanda, if there's not any other questions, I think we're all wrapped up.
Yeah, I think so. Thank you guys both today for presenting the webinar. We appreciate it. Everyone, you can contact Joe and Mike through the contact information on the screen there with any additional questions or additional information. And we will be sending out a recording of this webinar in the next day or two, so please watch out for that, and you can rewatch it then. But thank you all for attending today. We appreciate it, and have a great day.
Yep, thank you.